So, we can proceed to the last major topic. At least some authors would enumerate ito daw ang defective contracts. Rescissible, voidable, unenforceable, and void. The Civil Code enumerate defective contracts. Wala naman. Ang Civil Code would only provide for chapters. May chapter on rescissible, voidable, unenforceable, and void. I also cannot agree on void contracts being defective contracts because void contracts are not merely defective contracts, they are actually inexistent contracts. Iba ang defective, iba ang wala. Ang defective na makina, nandyan ang makina. Pero pag walang makina, ay bibili ka pa ng makina, di ba? Thus, ang tamang classification would be yung rescissible, voidable, and unenforceable, they are defective. In fact, under the law, ang classification ng contracts na ito, they are valid. But they are defective precisely because rescission is a remedy as to rescissible contracts. Annulment would be a remedy sa voidable or annullable contracts, and ang remedy doon sa unenforceable simply is you just object to the presentation of evidence to prove the existence of the contract. Thus, ang mas magandang classification, mayroong valid contracts, pero under valid, may valid and binding, pero mayroong defective. On the other hand, may void contracts. Can there be a ratification of these contracts? Obviously, hindi ang valid and binding. There's nothing to ratify. It's valid and binding already. But void contracts, can they be ratified? Under 1409, these contracts cannot be ratified. Although, is there a contract which is void, which can be ratified? I dare to say yes. 1898 would tell you that a contract which is void can be ratified. But this is an exceptional scenario where an agent entered into a contract in excess of his authority or outside the scope of his authority, and the third person with whom he entered into such contract knew that the agent is acting outside or in excess of his authority. That contract is not merely unenforceable, it is a void contract. However, the law also expressly provides that that contract can be ratified by the principal. Aside from that contract, again, void contracts cannot be ratified. As to defective contracts, can they be ratified or are they subject to ratification? There is no question as to voidable and unenforceable contracts. They can be ratified. However, as to rescissible contracts, there is nothing to ratify. Rescissible contracts cannot be the subject of ratification because there is nothing wrong with the essential requisites of this contract. In fact, if there is a defect in the contract, the defect goes into the fact that a party to the contract or a third person would suffer economic prejudice or lesion in relation to the contract. Yun ang defect. So there is no defect as to consent, as to the object, as to cause. There is nothing to be ratified. Kung ang defect sa rescissible goes into damage or economic prejudice, ano effectively ang defect sa voidable? Sa voidable, the defect basically would pertain to incapacity, which pertains to the capacity to act. The capacity to act is just the power to do act with legal effects. Aside from incapacity, the other reason why a contract would be voidable is because of vitiation of consent. Basically, wala nang iba. Although, if you still remember, if you studied this contract entered into by a spouse over a property like a sale, over a property which is a conjugal property. If you remember, under the Civil Code of the Philippines, this contract is a voidable contract. But under the Family Code, obviously this contract is not merely voidable, it is really void. I think this is a better classification of the contract because there's really lack of consent of one of the spouses, and therefore it should not merely be voidable, it should be void, although the Family Code would consider this contract as a continuing offer to the other party who did not give his consent until that contract is withdrawn by either of the parties. Now, unenforceable, a few reasons, okay? Basically, I mentioned one, because it is not in the form prescribed by law under the statute of frauds, or maybe because both parties are incapacitated, kaya yun yung depekto, or pangatlo, because while the person was authorized to represent the other, he acted in excess or outside the scope, or wala talaga siyang authority. So, unenforceable. Those are basically the defects, okay? Of course, void contracts basically because of lack of one of the essential requisites or because it is contrary to law, morals, etc. Okay? So let's start with rescissible contracts. When would a contract be rescissible? Take note, the contract here itself is rescissible. Because rescission is a remedy, does it mean that the contract is rescissible? Not necessarily. You must have studied in 1191 that rescission may be a remedy not because the contract is rescissible, but because there was substantial breach. The reason why rescission is a remedy under 1191 is not because there was economic prejudice suffered by one of the contracting parties by the fact that the contract was entered into, but because there was substantial breach of one of the parties or fundamental breach. Here lies the difference between rescission under 1191 and rescission under rescissible contracts, 1380, 1381. In one case, decided by the Supreme Court in 2008, an action for rescission first was filed. Now, a motion to dismiss was filed because allegedly the action had already prescribed because the action was filed more than 4 years from the date of the contract. Was this motion granted? Tama ba ang motion? Because the action was filed more than 4 years from the date of the contract. The Supreme Court said that the reason why this motion was not appropriate, the movant obviously was in error, because the ground for rescission here was not because of an economic prejudice, where the action for rescission should be filed as a rule within 4 years from the date of the contract. Thus, in rescission, under 1191, if the contract is in writing, the action would prescribe only after 10 years. So magkaiba ang rescission sa 1191 and 1380, 1381. Okay? Of course, the other major difference is under 1381, this is a subsidiary remedy. There should be no other available legal remedy to the aggrieved party. Whereas in 1191, the rescission there is a principal remedy. He can invoke that remedy without invoking any other remedy. Of course, you should know that yung rescission under 1191 was just the result of an erroneous translation of the Spanish term. Ang tamang term sa English should have been resolution. Nagkamali, kaya pinapahirapan tayo. There are two kinds of rescission under the Civil Code, when in fact, 1191 should pertain to resolution. And therefore, in cases decided by the Supreme Court itself would use the term resolution in relation to rescission under 1191. Ang totoong rescission nasa 1381. So when would a contract be a rescissible contract? A contract would be rescissible only because the law so provides. There has to be a law which declares the contract to be a rescissible contract. And the most number of rescissible contracts enumerated is in Article 1381. Nandyan ang pinakamaraming rescissible contracts. There are a few other contracts or agreements which are also rescissible as provided under the Civil Code. But into 1381, when the guardian enters into a contract involving a property of his ward and the ward suffered lesion of more than 25% or 1/4 of the value of the thing. First, you should always bear in mind that in that contract, if this is a sale, madaling isipin sale, the buyer must not be the guardian himself for the contract to be rescissible. Because if the buyer is the guardian, 1381 is not applicable. What is applicable is, as we have discussed, 1491, where the guardian is prohibited from acquiring by purchase. Hindi lang rescissible ang kontrata sa 1491, kundi void. But if the buyer is a third person, 1381 may apply, can be invoked. But another requirement is that clearly, the property must be the property of the ward. Kung property ito ng guardian, wala tayong pakialam kung ibenta niya ng palugi, di ba? The property must be the property of the ward. He is just representing the ward in that contract. Of course, the law further provides that rescission may not be a remedy even if the contract is rescissible because the ward suffered lesion of more than 25% when the court approved such contract. Does it matter if both parties to that contract faithfully complied with the respective obligations? It doesn't matter. The contract would still be rescissible. Even if the guardian delivered, the buyer paid, the contract still is a rescissible contract because the ward suffered lesion of more than 1/4 of the value. Same rule as to representatives in relation to the properties of the absentees, more than 1/4 ang lesion. But a problem here as to the first two paragraphs would pertain to a scenario where, what if the property of the ward was sold for a price where the ward suffered lesion of more than 25%? Let's assume sale of shares of stocks, the value of the shares of stocks, 100,000 for 100,000 shares, meaning 1 peso per share. And the guardian sold the shares only for 60,000. So there is lesion of more than 25. In fact, 40% of the value. If thereafter the ward who attained the age of majority filed an action for rescission, would rescission only pertain to the portion of the shares of stocks where the ward suffered lesion? Halimbawa, di ba the buyer paid 60,000? So lesion was only up to the 40,000 shares. Should rescission only pertain to the 40,000 shares? Or should rescission pertain to all the 100,000 shares sold to this buyer? There appears to be an inconsistency between Articles 1384 and 1385. Because in 1384, the law provides that rescission shall only be to the extent necessary to cover the damages caused. So apparently, if you will apply 1384 only to the extent of the damage caused, edi only to the extent of 40,000 shares. Isoli lang ang 40,000 shares, okay na. Di ba? But if you will read 1385, the law provides it would create an obligation to return whatever was delivered. In effect, this is the usual effect of rescission, which is mutual restitution, sulian. Therefore, the buyer should return all the shares of stocks, as much as the ward, the former ward, would have to return the 60,000 which he received, di ba? Which is applicable in this scenario. I would agree with Professor Tolentino on this issue that under the first and second paragraph, ang applicable provision is 1385, where there would be an obligation to return. Mutual restitution would be the effect. Ang 1384 can only be invoked if the contract is rescissible because it is in fraud of a creditor or creditors. Okay? In a sense, this is understandable because, for example, this debtor is indebted in the total amount of 100,000 na lang. Debt niya 100,000. He sold 3 parcels of land, identical. Ang value ng bawat isa, 100,000. Now, if rescission would be granted in favor of the creditor because the sale was in fraud of the creditor, should rescission pertain to all parcels of land, or would it suffice that rescission should only pertain to 1 parcel of land? I think 1384 would be applicable only to the extent necessary to cover damage. Ang kanyang unpaid debt is only 100,000 and the value of 1 of the parcels of land is already 100,000. That would cover already the damage that may be caused to the creditor, and therefore there should be no rescission as to the sale involving the 2 other parcels of land. Okay? But that is as far as contracts in fraud of creditors. Otherwise, As to the other scenarios, mutual restitution should be a remedy. In other words, again, in this effect of rescission, the party invoking this remedy must be in a position to return what he received pursuant to the contract. Otherwise, rescission may not be a remedy. Okay? Before discussing contracts in fraud of creditors, okay, the last scenario where a contract would be rescissible would be a contract involving a thing which is under litigation. Example, the thing was sold by the defendant without the knowledge of the plaintiff and obviously without the knowledge and approval of the court. That sale between the defendant and the third person under the law is a rescissible contract. Ang common misconception dito for this paragraph is because the property was sold, the property under litigation, this would only be in fraud of a creditor, and therefore there has to be a proof of fraud in order for the contract to be rescissible. Wrong. Iba ang contracts in fraud of creditors, iba ang things under litigation. Things under litigation, the fact that the thing is under litigation and it was sold by the defendant to a third person, the law provides that the contract is rescissible. The premise of this article, however, of this provision is that the plaintiff won. Nanalo ang plaintiff sa kaso. Kasi kung natalo siya, pakialam niya kung ibinenta ng defendant ang property na yon, di ba? Even if that was sold without the consent of the plaintiff, if the defendant won in that case, rescission obviously would not be a remedy. Ang pinaka-common na case, kasi wala pang ang tanong sa bar exam, would pertain to contracts in fraud of creditors. Okay? The question here first is, how is fraud proven? How do you prove fraud? Because you have to prove that the contract was in fraud of a creditor, so there has to be evidence that the contract was in fraud of a creditor. Okay? The law would actually provide for two ways of proving fraud. You can simply invoke a presumption, or you may present evidence which are known as badges of fraud. Ang pinakamaganda ay combination. Meron ka ng presumption of fraud, may badge of fraud ka pa or badges of fraud. And this was really the scenario in the case of Sadora versus Cabaliw. In Sadora versus Cabaliw, the wife filed an action against the husband for support. The court decided the case in favor of the wife, and therefore here the wife is the creditor of the husband. After this judgment was promulgated, the husband sold his properties to his son-in-law. Now, is this sale of these parcels of land in fraud of a creditor? The Supreme Court said yes. Why? Again, two ways. Una, may presumption of fraud na dito, mayroon pang badges of fraud. As to the presumption of fraud, when would a presumption arise that a contract or a transaction is in fraud of a creditor? Two scenarios. This may arise when a contract is onerous, or this may arise when a contract is gratuitous. That the contract was in fraud of a creditor, even if the contract is an onerous contract, would arise if the contract was entered into after a judgment was rendered in favor of a creditor, or there was an order of an attachment against the debtor when this transaction was entered into. Take note under the facts, sa Cabaliw versus Sadora, the sale was entered into after a judgment was rendered in favor of the wife, and therefore under the law, this is presumed to be in fraud of a creditor. I would, however, agree that this is only a disputable presumption. Just because the sale happened after the decision in favor of a creditor, while the presumption would arise na in fraud, this may be rebutted. Now, pwede ring after an order of attachment was issued by the court, ayun, nagkaroon ng onerous transaction. Okay? Again, the transaction would be in fraud. Is it required that the judgment or order should already be final and executory at the time the transaction was entered into by the debtor? The law did not so require. Otherwise, kung magre-require ka pa ng judgment to be final, by that time, naubos na ang properties ng debtor. Because upon receipt of the decision or the order, he can sell all his properties or dispose of his properties to other persons in order for his creditor not to be able to levy upon any of his properties. If the transaction is gratuitous, when would a presumption arise? Example, in case this debtor had properties, the value of which mga 10 million. Out of the properties, he donated properties na ang value ay 7 million. May creditor siya. Ang natira na lang 3 million. Is the donation therefore presumed to be in fraud of his creditor? Well, not necessarily. Because the presumption will arise only if, with the donation, he did not reserve sufficient properties to cover his debts. So kung ang debts niya ay only 1.5 million, ang properties niya na natira 3 million pa, ay walang presumption. Pero if his debts, unpaid 5 million, itinira lang niya 3 million, the presumption arises that this is in fraud of a creditor. Now, as to the badges of fraud, in the case of Caballero versus Sadora, one badge of fraud is the close relationship between the parties to the contract. Kung ang seller tatay, ang buyer anak, there is obviously a close relationship. If you read the case of Hong Kong Shanghai Bank versus Poly, ganun ang scenario. In Caballero versus Adora, the seller was the father-in-law, the buyer was the son-in-law. But I have to warn you that close relationship between the parties alone per se cannot be a basis for the court to conclude that the contract was in fraud of a creditor. Okay? Mag-isa siya, hindi pa sufficient. Because may there be a valid and binding sale, a good faith sale between a parent and a child? Of course. I would ordinarily claim that normally ang children mas mayaman kaysa parents. Kasi kung ang children mas lalong naghirap, either walang silbi ang parents or more often than not, pasaway ang anak. Diba? Otherwise, normally the parents would really strive na maging mas maganda ang buhay ng mga anak. That's why the children may have the capacity to buy the properties of the parents. Although, bakit mo pa bibilhin? Bigyan mo na lang ng pera ang tatay mo o ang nanay mo. Pero pwede rin, nabilhin mo. But in this case, there were other badges. And another badge of fraud in a contract of sale would be the fact that the buyer did not take possession of the property after the sale. Mukhang hindi totoong sale ito. Mukhang simulated sale lang. Kasi kung tunay ito na sale, after the sale, dapat who would be in possession? The buyer. The other badges would include yung inadequate consideration of the conveyance. In one case, nakalagay fictitious consideration of the conveyance. If the consideration is fictitious, would the contract merely be rescissible? I don't think so. This should not be a badge of fraud which would make the contract rescissible. Because if the consideration is fictitious, the contract should be void, not merely rescissible. Because then there would be lack of one of the essential requisites. Pero inadequate or grossly inadequate, mukhang tama yon. Because for example, if a person is a debtor, ang debt niya ay 500,000, and he sold his property, ang value ng property niya 1 million, binenta lang at 50,000, mukhang that is in fraud of a creditor. Kung gusto mo talagang ibenta at bayaran ang creditor mo, you should have sold it at its value. Diba? Para mabayaran mo ang utang mo. Thus, inadequacy of the price is a badge of fraud. But another badge of fraud would pertain to a sale by a debtor, and the sale is a sale on credit by a debtor who is already insolvent. May gana pang magpautang, samantalang insolvent na siya. Kung insolvent ang tao, dapat he should sell his properties on cash basis so that he would be able to comply with his obligations. Again, a sale upon credit or on credit by an insolvent debtor is also a badge of fraud. So again, either a few badges of fraud or a presumption of fraud or a combination could be the basis of the court in concluding that the contract indeed was in fraud of a creditor. Okay? Then, into the other requirements for rescission to be a remedy, I mentioned already that under this contract, rescissible contracts, this is a subsidiary remedy. He must have no other legal means to obtain reparation for the damage incurred. Another requirement as a consequence again of rescission again is he must be able to return whatever he may be obliged to restore. Okay? Mutual restitution. But one other scenario. In a sale, where the seller was the debtor, mayroon siyang creditor siyempre, but he sold his properties to this buyer in fraud of a creditor. The law provides that rescission would not be a remedy if the thing which is the subject of the contract is lawfully in the possession of a person who did not act in bad faith. So what if the buyer acted in good faith? Hindi niya alam ang intention ng debtor, ng seller, na to defraud pala his creditor. Would rescission be a remedy? Or, in that provision, is it required that the person who may be in legal possession should be a third person in relation to the sale? It is claimed by an author or two authors that this third person can only be another party in relation to the buyer. For example, the buyer resold the thing to this third person. Ito daw lang ang pwedeng mag-claim ng legal possession if he is in good faith, which is wrong. I would agree to the position that the third person referred to, who may be in good faith, is the buyer from this debtor. He is a third person in relation to this debt. As long as the buyer is a buyer in good faith and for value, he would be protected under the law. And the rescission of this sale would not be a remedy. Okay? I mentioned as far as the action for rescission of the contract to prosper, as a rule, it should be filed within 4 years from the date of the contract. However, if the ground for the rescission is because the contract was in fraud of a creditor, the law provides that the 4-year period will be reckoned from the discovery of the fraud. However, a qualification to this rule, discovery of the fraud, it need not be the actual discovery. It could be from the time of the registration of the sale. Because in the case of Hong Kong Shanghai Bank versus Poly, the action for rescission was filed within 4 years from the time the bank actually discovered. But it just happened that the sale was registered more than 4 years from the filing of the action. The Supreme Court ruled the action had already prescribed. So tingnan nyo kung may registration, because it will be from the time of registration that the 4-year period will be reckoned. Okay? Of course, if the ground pertains to contracts entered into by the guardian, the 4-year period will be reckoned from the time the ward attained the age of majority or recovered from the incapacity, hindi from the date of the contract. Okay? Hong Kong Shanghai Bank versus Poly. Voidable contracts, again, the defect only pertains to incapacity and vitiation of consent. Because one of the parties is a minor, one of the parties is insane, therefore the contract is voidable. And these rules, as far as voidable contracts, are applicable even to other agreements like partition, as seen in this problem. X was the owner of a 10,000 square meter property. X married Y, and out of their union, A, B, C were born. After the death of Y, X married Z, and they begot as children D, E, F. After the death of X, the children of the first and second marriages executed an extrajudicial partition of the first stated property on May 1, 1907. D, E, F were given 1,000 square meter portion of the property. They were minors at the time of the execution of the document. D was 17 years old, E was 14, F was 12. And they were made to believe by A, B, and C that unless they signed the document, they will not get any share. Z was not present then. In January 1974, D, E, and F filed an action in court to nullify the suit, alleging they discovered the fraud only in 1973. Can the minority of D, E, and F be a basis to nullify the partition? Explain your answer. How about fraud? Explain your answer. Okay? A basis to nullify, well, strictly speaking, it is not to nullify. It is to annul the contract. Can the minority be a basis? Yes. When they entered into this agreement for partition, they were minors, 17, 14, and 12. And that was 1970. When the action was filed in 1974, the action was filed within 4 years, definitely, from the time D attained the age of majority. Now, D, E, and E were definitely minors in 1974. Thus, minority would be a ground. How about fraud? Definitely, fraud is also a ground for the annulment of a contract. As obviously, yung minority pertains to incapacity, the fraud pertains to vitiation of consent. Why there was fraud? Because they were made to believe by A, B, and C that unless they sign, they will not get any share. That, I believe, also is a fraudulent representation. A provision under the law on succession expressly would provide for the applicability of the provisions on contracts in relation to this scenario. We have mentioned earlier that voidable contracts are subject to ratification. Ratification would require the consent of both parties to the contract. The answer is no. Because only the party who is incapacitated or only the party whose consent was vitiated would have the right to institute an action for annulment, and therefore he alone can ratify the contract. Kung sino ang nambugbog, of course, hindi siya pwede mag-ratify ng contract. The one upon whom violence was employed, siya ang pwede mag-ratify ng contract. Okay? But may a third person have the right to institute an action for annulment? The answer is yes, as long as he is subsidiarily obliged to that contract. Ang mga subsidiarily obliged ay yung mga guarantors, pledgers, mortgagors. They are subsidiarily obliged, and therefore the law would give them the right of action to institute an action for annulment. Otherwise, as a rule, third persons who are not subsidiarily obliged would not have the right to institute an action for annulment. However, the Supreme Court ruled in one case that a third person may have the right to institute an action for annulment if he can show prejudice if the contract will not be annulled. A good scenario would pertain to this where a thing was sold to a buyer but there was vitiation of consent on the part of the seller. Thereafter, the seller this time, wala nang vitiation of consent, sold the same thing to a second buyer. The second buyer is not a party to the first, not privy to the first, not even subsidiarily obliged to the first, but he will definitely be prejudiced if the first sale is not annulled. Diba? Obviously, the first sale is annullable because there was vitiation of consent. But the third person, I would agree, would have the right to institute an action for annulment. The third person here is the second buyer. Ratification, of course, may be express or implied. The fact that the party who has the right to institute an action for annulment accepted benefits from the contract may already be considered as a form of ratification. An example dito would be if the minor sold probably or maski leased his parcel of land when he was only 17 years old, thus the contract would be voidable. Despite the fact that he already reached the age of majority, naku, mga 2.5 taon, he continued to receive the rentals. That would be considered as a form of ratification, implied ratification, because he accepted the benefits arising from such contract. Okay? Annulment would also have similar effect as rescission. It would result in mutual restitution. In other words, if the aggrieved party is not in a position to return what he received, annulment may not be a remedy. But basically, it would depend on the reason why he cannot return. Because if he cannot return because the thing which he's supposed to return was lost due to his fault, he can no longer have the contract annulled. But if it was lost due to a fortuitous event, lalo na kung due to the fault of the other party, annulment would still be a remedy. Of course, if the action had already prescribed, again, the action may no longer prosper, okay? Aside from there was ratification. So into unenforceable contracts. These contracts, again, cannot be enforced even through court action unless ratified. And if there is a proper objection, obviously there is no ratification. In fact, a kind of ratification is when there is failure to properly object, when oral evidence is presented to prove the existence of the contract. Now, what contracts are considered as unenforceable contracts? Basically, I mentioned the three already. Contracts where both parties are incapacitated are unenforceable contracts. Again, if one of the parties ratified, then it will have the effect as if only one of the parties is incapacitated. Therefore, the contract would be voidable. Another contract which is unenforceable is a contract entered into by a person in representation of another, but he does not have the authority of that person. Unless, of course, I mentioned if he has legal representation. Maybe he has the authority of the law or he was authorized by the court to enter into such contract. Now, a third group of contracts which are unenforceable, I mentioned already, are contracts enumerated under Article 1878, entered into by an agent without a special power of attorney. The last group of contracts, which are really the favorite contracts sa bar exams, are those contracts covered by 1403, more popularly known as the Statute of Frauds. Let's start with the first in the enumeration. The question here would be, a contract for a piece of work, would it be covered by the Statute of Frauds or may it be covered by the Statute of Frauds? If not in writing, may that be unenforceable? Or maybe a contract of agency, if not in writing, may it be covered by the Statute of Frauds? A misconception of at least one author is the claim that the Statute of Frauds or 1403 would only apply, can only be invoked if the contract is either a sale or a lease. That is definitely wrong. Because under 1403, any agreement under its terms is not to be performed within 1 year and it is not in writing would be unenforceable. Again, any agreement or any contract. Thus, a contract of agency, a contract for a piece of work, or any contract for that matter, if under the terms of such contract, it is not to be performed within a year, then it would be unenforceable if not in writing. This particular scenario, as to this paragraph under 1403, is not really consistent with the original purpose of the Statute of Frauds. This is somehow a deviation because the purpose of the statute is to prevent fraud being committed by one party against the other because the contract is not in writing. However, in this particular scenario where the agreement is not to be performed within 1 year, it's not really because fraud is to be prevented, but rather because this recognizes the fact that even honest men may commit mistake. Well, I would hear from my students that if they cannot give the correct answer, but that they have read on the matter 3 days ago. Pero ngayon, hindi na nila alam. Nakalimutan na nila ang sagot. Thus, if it is not to be performed within 1 year, lalo na, di ba? So, nagkakalimutan na. And this is especially true in relation to obligations. In psychology, I have read somewhere that our brain has this function, parang may power siya to shut off yung mga bad memories. And therefore, you would not normally remember yung mga experience mo na hindi maganda. At ang obligation ay hindi masyado maganda, di ba? Kaya, it would not be unusual if you have a friend who is indebted to you, whom you would see every day. As a creditor, ikaw, you would remember him. Uy, itong taong ito, may utang ito sa akin. Pero siya wala lang, as if wala siyang utang, di ba? Not because probably of fraud, but probably because he actually forgot that he has an obligation. Kaya ang kailangan medyo i-remind mo siya, di ba? Lalo na kung in writing. Thus, even a contract for a piece of work, if not in writing and under its terms is not to be performed within 1 year, may be covered by the Statute of Frauds. Okay? Itong bar exam question. Answer true if the statement is true or false. If the statement is false, explain your answer in not more than 2 sentences. Actually, 5%, 1 point each yan. There are 5 scenarios, okay? An oral partnership is valid. That is true. An oral partnership is valid. Technically speaking, even if one of the parties contributed an immovable property, what the law requires is not the partnership itself should be in writing. What the law requires is that there should be an inventory of such immovable property which should be signed by all the contracting parties. Okay? But of course, there is a debate here. The debate in partnership, total nandyan na rin lang ang tanong, is if an immovable property is contributed, is it not also required as stated under 1771 in relation to 1773 that the partnership shall be in a public instrument? In fact, it is said that the inventory should be attached to the public instrument. Well, I would agree here with Professor Bautista, Professor Agbayani, that that requirement as to form is not necessary for the validity of the contract. If you read the provision, there is nothing in the provision which would tell you that if the form is not complied with, the contract would be void. What is clear in those provisions is that if there is no inventory of such immovable property signed by all the contracting parties, the partnership would be void. In other words, while the law requires a form, public instrument, as to the partnership, if there is an immovable property contributed, that form is not necessary for the validity of the contract. Professor Bautista would tell us that it is necessary to protect third persons, okay? So that they would know kung ano ang purpose ng partnership, etc., when they deal with the partnership. But I mentioned to you this scenario, oral promise of guarantee is valid and binding, okay? A guarantee is entered into always by a third person. The guarantor here is not the principal debtor. Walang guarantor na siya din ang principal debtor. And therefore, this would fall under the statute of frauds, a special promise to answer for the debt of another. And since this is not in writing, it's merely an oral promise of guarantee, then it cannot be a valid and binding contract. It would be unenforceable under 1403. Now, into this case, Cabagi versus Auxilio. The father and his son had a verbal agreement with another father with his daughter that the son and the daughter will be married, but before the marriage, the father and the son will cause the repair of the house of the father and the daughter. This agreement appears to be a usual agreement then because normally the reception after the wedding would be at the house of the bride, diba? Normally doon. Now, pursuant to this verbal agreement, the father and the son had the house of the father and the daughter repaired. For that, they spent around 700 pesos. Well, at that time, malaking amount na yon. However, after the house of the father and the daughter was repaired, the daughter refused to marry the son. And because of that, the father and the son filed an action for damages against the father and the daughter. Did this action prosper? Well, sabi ng Supreme Court, let's consider the causes of action in this case. As to the father's action, the father of the son, as against the other father and the daughter, this is an action based on an agreement in consideration of marriage. And therefore, under the statute of frauds, it has to be in writing. Since this is merely a verbal agreement, that agreement is unenforceable. The action was dismissed. However, as to the son, who was one of the plaintiffs against the daughter and the father of the daughter, the Supreme Court ruled that this pertains to an action under a mutual promise to marry, which is not covered by the statute of frauds. Sabi ng statute of frauds, an agreement made in consideration of marriage other than a mutual promise to marry. So, the Supreme Court remanded the case back to the trial court for further proceeding. Now, I would warn you, however, this must have been discussed sa persons that ordinarily, a mere breach of promise to marry is not actionable. However, the manner of the breach can be the basis of an action for damages. If you remember this case of Wasmer versus Velez, where the groom sent a telegram only about a day before the wedding to tell the bride that the wedding will not push through, hindi na siya magpapakasal, at the time when expenses have been incurred for the wearing apparel, for the food, etc. And invitations have all been sent sa mga ninong, etc. The Supreme Court said that this act of the defendant was contrary to morals under the provisions on human relations for which he was held liable. Although actually, when the Code Commission recommended yung civil code, yung proposed civil code of the Philippines, there was a whole chapter for liability in case of breach of promise to marry. Although Congress found it necessary to delete the entire chapter on breach of promise to marry. Otherwise, baka lahat sila maging liable. But apparently, okay naman, diba? Because if someone would tell you that I will marry you, dapat tingnan mo kung seryoso o hindi. Kung nabola ka lang, sorry ka na lang, diba? Okay? An agreement made in consideration of marriage is required to be in writing, otherwise it would be unenforceable. But of course, I would definitely agree that the most common contracts which are covered or may be covered by the statute of frauds are contracts of sale and lease. Let's start with a contract of sale. If the contract of sale involves an immovable property and it is not in writing, it will be unenforceable. Maybe this is for the second time. I would have to emphasize that the statute of frauds does not require the contract to be in a public instrument. The law merely requires the contract to be in writing to be a valid and binding contract. So, in sale of an immovable property, as long as it is already in writing, that would be a valid and binding contract between the parties. But ordinarily, it will not bind third persons because a private instrument cannot be registered and therefore only the parties will be bound except, again, those third persons who have actual knowledge of this contract. Now, does it matter if the price agreed upon in this contract of sale involving an immovable like a parcel of land is 300 pesos only or less than 500? The answer is no. The price in sale of immovables is irrelevant. Although others would ask, meron bang sale of parcel of land na 400 pesos? Of course, there were such sales before. But in sale of movables, example, if A sold a bag to B, which bag he purchased 3 days ago for 3,500, but he sold it to a friend probably today, and it is not in writing, therefore it is covered by the statute of frauds? Not necessarily. What is relevant under the statute of frauds in sale of movables is not the value of the thing but the price agreed upon by the parties. And therefore, even if the value is 3,005, if he sold it only for 350, that will not be covered by the statute of frauds. The law on sales follows the general rule in contracts that lesion, as a rule, does not affect the validity of the contract. Kung gusto mong ibenta ng palugi, okay lang yan under the law on sales. Finally, a contract of sale involving a movable property or a personal property where the price is less than 500, mga tipong 300 pesos lang, may that contract still be covered by the statute of frauds? Movable, the price less than 300, the answer is yes. It may still be covered if it would fall under the first paragraph. If under the terms of the contract, it is not to be performed within 1 year. Ang usapan nila, the seller will deliver the object of the sale after 16 months and the price will be paid upon delivery. That would be covered by the statute of frauds. In relation to lease contracts, in a contract of lease which is for a period of 3 years and it is merely a verbal contract, would that be covered by the statute of frauds? The answer is not necessarily. A common mistake is to claim that because the lease is more than 1 year and it is not in writing, it is unenforceable. That is wrong because you should read that provision in its entirety. What is really required to be in writing is a contract of lease for more than 1 year and the object or subject matter of the lease is a real property. So kung car lang ang leased property, maraming nagaganon, lease of a car for more than 1 year, maybe 3 years. Even if it is not in writing, that would be a valid and binding lease. Again, it is the lease of a real property for more than 1 year which is required to be in writing under the statute of frauds. Kaya lang when we go to agency, 1878 would include a contract of lease entered into by an agent. If the contract of lease would involve a real property and the period is more than 1 year, not only should the lease contract be in writing, the agent must have a special power of attorney. So, ang bar exam questions would sometimes be a combination of 1403 and Article 1878 in relation to the enforceability of such contract of lease. Thus, this bar exam questions. X came across an advertisement in the Manila Daily Bulletin about the rush sale of 3 slightly used Toyota cars, model 1989, for only 200,000 pesos each. Finding the price to be very cheap, and in order to be sure that he gets 1 unit ahead of the others, X immediately phoned the advertiser Y and placed an order for 1 car. Y accepted the order and promised to deliver the ordered unit on July 15, 1989. On the said date, however, Y did not deliver the unit. X brings an action to compel Y to deliver the unit. Will such action prosper? Give your reasons. A good answer is that this action will not prosper if there is a proper objection. But if oral evidence was presented to prove the existence of the contract and there was no proper objection, the action may prosper. Actually, I'd say may prosper considering that other factors may be relevant. Okay? As this obviously involves a sale of a movable property and the price stated under the facts is obviously more than 500 pesos. Under 1403, this contract should have been in writing, and since it was merely a telephone call, phoned the advertiser, it was obviously a verbal agreement. Then this one. A and B entered into a verbal contract whereby A agreed to sell to B his only parcel of land for 20,000 and B agreed to buy at the aforementioned price. B went to the bank, withdrew the necessary amount and returned to A for the consummation of the contract. A, however, had changed his mind and refused to go through with the sale. Is the agreement valid? Will an action by B against A for specific performance prosper? Take note again that there are 2 questions in this problem. Is the agreement valid? That's the first question. The second question, will an action by B against A for specific performance prosper? These 2 questions are really different from each other. So the first question, is the agreement valid? The answer is yes. This is a valid contract, although this cannot be enforced through court action if there's a proper objection, because this involves a sale of an immovable property which is not in writing, thus covered by the statute of frauds. Again, unenforceable contracts are valid contracts. Now, to the second question, will an action by B against A for specific performance prosper? It will not prosper if there is a proper objection. I would always agree with the term proper objection because you should not object after the presentation of evidence, diba? Ipipresent pa lang ang evidence, ang testimony ng witness, there should already be an objection. By now, you should remember that when there is a witness who would be testifying, there would be an offer of the evidence before he would actually testify. So you can already object at that moment. Huwag mong hintayin na nakapag-testify na siya because by then, there would already be ratification. But there may be a claim that this contract was taken out of the operation of the statute of frauds because there was partial fulfillment. Under the facts, B went to the bank, withdrew the necessary amount, and returned to A. Would that actually be considered as partial fulfillment? Far from it. Malayo. That is only preliminary to the fulfillment of the obligation to pay. But it is not the same as he had paid. He only planned to pay. Nag-prepare lang sila for the payment, but there was not even partial payment. And therefore, still, the contract is covered by the statute of frauds. In the same manner, there's one. Suppose that in an oral contract, which by its terms is not to be performed within 1 year from the execution thereof, one of the contracting parties has already complied within the year with the obligations imposed upon him by said contract. Can the other party avoid fulfillment of those incumbent upon him by invoking the statute of frauds? The answer is no. He can no longer invoke the statute of frauds if there had been performance already by one of the parties, because the reason why a person can invoke the statute of frauds because the contract is still wholly executory, thus there is no proof of the existence of the contract. If there had been performance already of the contract, even only partial, then it presupposes that there was a contract in the first place, and therefore the reason for the law for the statute of frauds would no longer be present. Okay? Again, this statute of frauds is intended to prevent prevent fraud being committed, not to protect fraud that may be made by one party over another. Okay? But this is a good question. One half of a parcel of land belonging to A and B was sold by X to Y for the amount of 1,500. The sale was executed verbally. 1 year later, A and B sold the entire land to X. Is the sale executed verbally by X to Y valid and binding? Reasons. Take note, the sale between X and Y is a verbal sale, and this involves a parcel of land. And on its face, it appears to be covered by the statute of frauds. An alternative answer was this, that even if X was not the owner at the time of the sale, when he thereafter acquired ownership, because A and B sold the entire land to X, by operation of law, ownership passed to his own buyer, to Y. And apparently the basis of this answer is 1434. Is 1434 really applicable? And therefore, the contract between X and Y would be a valid and binding contract. X therefore would not be allowed to claim that at the time of the sale, he was not the owner, and therefore ownership cannot pass to Y. With due respect to that alternative answer, I also cannot agree, because for 1434 to apply, the law further requires that there must have been delivery of the thing by the seller to the buyer. Even if the seller was not the owner and no right to sell, he must have delivered the thing to the buyer in order for ownership to automatically pass to the buyer the moment the seller acquires ownership over the thing. Under the facts, was there any mention of delivery? Mukhang wala din, di ba? Kaya, I'd rather agree with an alternative answer. I think it was the last. That since this is a sale of an immovable property and this is a verbal sale, there being no partial fulfillment of any of the obligations arising from this contract, this is unenforceable under the statute of frauds. Okay? Now, if the suggested answer would be totally different from the alternative answer or answers, I would tell you not to panic. And sometimes sumasagot kayo, ang sagot niyo would fall under the alternative. Again, it's not something that you should worry about. Ang hindi ko lang natatanggap minsan is an answer, even the suggested, or sometimes the alternative answer, which is really contrary to law. Kung may batas on the matter or may ruling ang Supreme Court on the matter, medyo hindi talaga katanggap-tanggap. Otherwise, if it can be the subject of a debate, okay lang yan. Pag may konting room for a debate, I can accept that, yung mga alternative answers. Because if there's one good reason why alternative answers are provided, is because there are resource persons who would not agree with the suggested answer. In other words, yung majority mag-agree sa suggested, pero merong iba na hindi talaga mag-agree. So it's a form of accommodation, pero hindi lang yon. Ang purpose also is to give the examiner an idea that one of the experts or resource persons would consider an answer, an alternative answer. So, kung yung expert nga pwede, lalo na dapat bigyan mo ng points ang examinee, di ba? Kung ang sagot niya kapareho ng alternative answer. Pero sa totoo lang, sometimes alternative answer is even a better answer than the suggested answer, okay? Now, I tell you, I have this conviction na I am one of those who would actually believe that it is not really the fact that you know all the answers to the questions. Okay? It is more on how you answer the questions which should make you a lawyer or at least make you pass the bar exam. Maski mali-mali ang mga sagot mo, mukhang hindi talaga ito ang tamang sagot. Kung mas maganda ang presentation mo, mas maganda ang arguments mo, mas papasa ka pa kaysa doon sa mga tama ang kanilang position, tama ang conclusion, hindi naman tama ang mga arguments, mali-mali ang arguments. Okay? I have this conviction because of personal experience. Okay? When I took the bar exam, I am a member of an organization, okay, undergrad. Pagdating sa law school, the three of us are members of the same organization sa undergrad. Went to 3 different law schools. Okay? So every Sunday after 5 p.m. after the exam, 3 of us would be brought to a place kung saan namin gusto. Okay? Gusto naming manood ng sine, kumain, uminom, etc. So we would normally be seated at the back of one car, sa isang kotse lang, and immediately we would be discussing the questions and our respective answers. Of the 3 normally, first Sunday, yung isa pa, kapareho ng mga sagot ko. The third one, ibang-iba talaga ang mga sagot niya. That was the first Sunday. The second Sunday, as we discuss again the questions and our answers, pareho uli kami ng isang examining. Okay? The third one, ibang-iba talaga ang sagot. Now, come the third Sunday, when we started discussing our answers, and na-realize nung isa, yung pangatlo, na mukhang iba talaga ang mga sagot niya, sabi niya, tama na. Wag na tayong mag-discuss ng mga sagot sa mga tanong na yan. The first lesson sa kwento na ito is this. Never discuss questions and your answers even during the month of September. Kung gusto nyo, pagdating ng October, November, December, araw-araw, i-discuss nyo, diba? Ang mga tanong, ang sagot. Because it will not help you in any way if you discuss the questions and the answers. Hindi madadagdagan ang points nyo. Mas maganda pa siguro, magdasal na lang kayo kaysa mag-discuss ng mga sagot. Pero ang clincher dito sa kwentong ito is this. Sino ang pumasa sa bar exam na yon? Siyempre ako, diba? Pero ang clincher dito is kaming tatlo pumasa. Maniwala kayo sa hindi, yung isang kapareho ko ang sagot, judge na ngayon, hanggang ngayon hindi makapaniwala ano pumasa yung isang kasama namin, di ba? Kasi it's all in the arguments. As a lawyer, you will not be always on the so-called right side. You will be presented with a case na parang patalo talaga. Mukhang parang walang pag-asa. But you just have to do your best. You just have to defend your client to the best of your ability. Malay mo, silat mo pa yung kabila, di ba? Manalo ka sa kaso na napaka-hirap i-defend. Okay? So, it's more on the arguments. Always make an argument. Okay? Yung iba na walang basis, walang argument, not merit even points. Okay? Just a few more points on the statute of frauds. Okay? Just because an agreement or a contract involves a real property does not necessarily mean that will be covered by the statute of frauds. For example, an agreement as to the partition of a parcel of land. Obviously, a parcel of land is an immovable property, but that agreement is not covered by the statute of frauds. The statute of frauds would be applicable if the action filed is to enforce a contract which is covered or to claim damages because of breach of that contract. Okay? Example, in a case where an ejectment suit was filed and the plaintiff was about to testify as to the existence of a verbal contract in relation to the land to prove his right to evict the occupant. And the lawyer of the defendant invoke the statute of frauds. Was it proper? Okay? Should the judge sustain the objection? Answer is no. Because the action filed is not an action to enforce an unenforceable contract, not an action to enforce a contract covered, not an action for damages based on an unenforceable contract. This involves a third person. Okay? The third person under the law cannot assail an unenforceable contract. Okay? So I mentioned a while ago this doctrine of part performance. Okay? The statute of frauds is only applicable if the contract is wholly executory in character. Thus, if there is even only partial fulfillment of the obligations arising from that contract would be taken out of the operation of the statute of frauds. The misconception, according to the Supreme Court, in relation to this doctrine is the claim that there should either be partial payment or partial delivery. Kapag wala daw partial payment or walang partial delivery, the doctrine daw is not applicable. That is not correct. Okay? Because partial fulfillment may pertain to any obligation arising from a verbal contract. Okay? Example, in a case decided by the Supreme Court involving a sale of a parcel of land, as verbally agreed upon, the buyer paid yung mga real property taxes. The buyer also had the property surveyed. The buyer also constructed a building more or less permanent in character. So far, are these obligations have anything to do with payment? Wala. These obligations have anything to do with delivery? Wala din. But nonetheless, the Supreme Court ruled because of partial fulfillment of the obligations arising from that contract, the contract was taken out of the operation of the statute of frauds. Again, ang fulfillment hindi kailangan related to payment or delivery. Okay? If a contract is covered by the statute of frauds and the plaintiff would want to present a witness who would testify without any document at hand. In other words, oral testimony lang talaga. Walang documentary evidence to be presented. And there is an objection under the statute of frauds. Necessarily, the judge should sustain the objection because the contract is covered by the statute of frauds. The Supreme Court would say, it depends on the purpose of the testimony. Because if the purpose of the testimony is to prove partial fulfillment, then the statute of frauds is not applicable. In other words, partial fulfillment may be proven wholly by oral testimony. No documentary evidence is required in relation to partial fulfillment. However, sabi ng Supreme Court, even if 3 witnesses would testify in court as to partial fulfillment, the court should not automatically conclude that there was in fact partial fulfillment. The court should satisfy itself based on the testimony that indeed there was partial fulfillment. Tama yan kasi maski 10 pa ang mga witnesses mo to prove partial fulfillment, kung mukhang mga sinungaling naman ang 10 ito, the court should not consider the testimony. Nasa weight na ng evidence ang question dito. On the other hand, yung statute of frauds does not pertain to the weight of evidence. The statute of frauds affects the admissibility of the evidence. In other words, if the contract is covered by the statute of frauds, the testimony may not even be allowed under this objection. It goes into the admissibility of the evidence. Of course, again, unenforceable contracts can be ratified. First, by the acceptance of benefits under such contract, but the other one is for failure to object to the presentation of oral evidence at the proper time. That is considered as ratification of this contract. In other words, the defense of this statute may be waived. I think that should be sufficient as far as unenforceable contracts are concerned. One last contract are void or inexistent contracts. Article 1409 enumerates contracts which are void. And somehow, I believe we have discussed each and every ground for nullity of contracts. Example, those whose cause, object, or purpose is contrary to law, morals, good customs, again, public policy. So if the cause or the purpose of the contract is contrary to public policy, it is not simply voidable, it is void. Now, those which are absolutely simulated or fictitious, again, are void contracts. I dare to say, not only absolutely simulated, but even relatively simulated contracts. The simulated contract itself is void, but they will be bound to the contract or transaction which they actually entered into. The third would pertain to those whose cause or object did not exist at the time of the transaction. There has to be such cause. Because if it did not exist, then one of the essential requisites is lacking, and therefore the contract would be void. One author, however, would claim that the cause daw or the object need not exist at the time of the transaction as long as it has the potentiality of existence. Is there anything good with this claim? Wala. Because there is a misconception here again that the object is a thing. The object is not a thing. The object is the subject matter of the contract. The claim of that author would have been good in a contract of sale, where a sale may be valid even if the thing is not yet in existence as long as it has the potentiality of existence. But in contracts, there has to be a cause. There has to be an object at the time of the transaction. Kasi kung wala kang subject matter, anong kontrata mo? O di wala. Diba? It does not pertain to the potentiality of existence of the thing. It is the subject matter of the contract. Those whose object is outside the commerce of men, we have discussed this already. Those which contemplate an impossible service, again, this is void. Those where the intention of the parties relative to the principal object of the contract cannot be ascertained, we have discussed when we discuss the rules on interpretation of contracts. Diba? But finally, the last paragraph would tell you those expressly prohibited or declared void by law. And this is one of the basis of the conclusion that those contracts covered under 1491 are void contracts, not merely voidable contracts, because they are prohibited contracts. Thus, they are void. Now, if there is one as to the effects, or if there are such effects in relation to void contracts. If you have read the case of Tongoy versus Court of Appeals, and a few authors would actually copy this statement of the court in their books, the Supreme Court in this case said, as a rule, a void contract produces no legal effect whatsoever. Is this an accurate statement of the law? As a rule, a void contract produces no legal effect whatsoever. The implication of this statement is that under certain circumstances, a void contract would produce some legal effects. Kasi as a rule lang eh. Una, by way of observation, if you would be reading decisions of the Supreme Court, I dare to say 90-95% or 99% of the cases, the Supreme Court would say a void contract produces no legal effect whatsoever. If you will read Article 1352, for example, if the contract has no cause or it has an unlawful cause, it produces no legal effect whatsoever. Diba? Hindi sinabi ng batas not as a rule because it really does not produce any legal effect. In the first place, the law considers this contract as inexistent. So if it is inexistent, how can it produce any legal effect? But sige, tingnan natin. If an action is filed to enforce that contract, would that action prosper? Absolutely no. Any action to enforce a void contract will never prosper because there is nothing to be enforced. However, ito ang scenario. If the contract is void and pursuant to that contract, one of the parties delivered maybe a sum of money or a thing to the other party, may he be able to recover what he delivered to the other party. Ordinarily, if the contract is an illegal contract, meaning the object or the cause is contrary to law, morals, etc., he can no longer deliver under the principle of pari delicto, or others would say in pari delicto rule. As to these contracts, illegal contracts, the Supreme Court would tell us that the court should leave them as they are. No aid should be given to either party to this contract. Again, under the in pari delicto rule. Translated to English, because they are equally guilty and therefore they should have no cause of action under that contract. Kaya lang, there appears to be exceptions to this rule that a party to an illegal contract cannot recover what he delivered pursuant to the contract. These exceptions are provided under Articles 14, 11, 12, 14, 15, and 16. I will mention 3 of these exceptions. First, if one of the parties to this illegal contract was incapacitated at the time the contract was entered into, he may be allowed to recover what he delivered to the other party. Is there wisdom to this exception? I think so. Precisely because he is incapacitated, he does not know the legal consequences of his act. Probably baliw siya o probably 12 years old lang siya. Kaya, even if the contract really is illegal and therefore void, still he should be allowed, he may be allowed, if public interest warrants, to recover what he delivered pursuant to the void contract. Pangalawa, despite the fact that the contract is an illegal contract, a party to such contract may be allowed to recover what he delivered if he repudiated the contract before the consummation of the contract or before damage is caused to a third person. Is this a good exception? I think so also. In other words, that party to an illegal contract recognized that he did wrong in entering into that contract. Nagkamali siya. So he repudiated the contract, although the law requires that he must repudiate before the consummation of the contract or before damage is caused to a third person for him to be able to recover what he delivered to the other party. Again, this is expressly provided by law. But this bar examination question, well, this question is objective. Distinguish briefly but clearly between inexistent and nullable. Inexistent, also known as void contracts, again, they are void contracts, whereas annullable contracts are valid contracts until annulled. Another distinction violation would go into inexistent contracts, again, cannot be ratified. Annullable contracts are subject to ratification. You can also distinguish one from the other in relation to the defect, why they are void or why they are annullable. Inexistent because one of the essential elements is lacking, or maybe because the contract is contrary to law, morals, etc. Whereas annullable contracts basically is a defective contract merely because of defect in the consent, either because the party is incapacitated or there was vitiation as to his consent. But this one, in 1950, the Bureau of Lands issued a homestead patent to A. 3 years later, A sold the homestead to B. A died in 1990, and his heirs filed an action to recover the homestead from B on the ground that its sale by their father to the latter is void under Section 118 of the Public Land Law. B contends, however, that the heirs of A cannot recover the homestead from him anymore because their action has prescribed, and that furthermore, A was in pari delicto. Decide. Ordinarily, when you answer questions, you answer the question based on the arguments of the parties. Huwag niyo nang pakialaman yung hindi naman ina-argue, di ba? Even yung mga korte normally would not anchor the rulings on a ground not argued by the counsels. Lalo na on appeal ay hindi ka pwedeng mag-argue on a ground not invoked at the trial courts. Kaya ang arguments lang talaga dito why the heirs cannot recover, dalawa. Because the action has prescribed and because of the in pari delicto rule. If you have to decide, are these defenses valid? As to prescription, obviously this is not a good defense because the sale made within 3 years from the grant under the public land law is a void sale. Any alienation of the land under this law within the 5-year prohibitory period is a void alienation. And again, as an action to have the contract declared null and void and to recover what was delivered pursuant to that void contract does not prescribe. Imprescriptible ang action. However, into the second defense that they cannot recover under the in pari delicto rule, again, this is one of the exceptions expressly provided by law under Article 1416, that when a law declares a contract to be void, but there is no inherent illegality in that contract, and the declaration of nullity by law is intended or designed to protect one of the parties to that contract, that person in whose favor the law would so provide its nullity may recover what he sold to the other party. Here, the prohibition under the public land law is intended to protect the grantee and his family, because if he will sell or alienate the property within that period, he will have nothing more to cultivate for himself and his family. Kaya, he would still have the right to recover the property as the contract is a void contract and the in pari delicto rule is not applicable to this scenario. Kung tinanong sana ito, if you were the counsel of the defendant of A, what defense would you raise? A better defense would have been laches, diba? Because the sale happened in 1953. The heirs filed this action. After the death, almost 40 years had elapsed. In a way, the grantee, the seller, is left on his rights, okay? And therefore, he may not be allowed to recover, or his heirs, under the principle of laches. That would have been a good. Pero dahil hindi tinanong, I will not recommend that you give that as an answer in this question, in this problem. Again, sagutan nyo lang kung ano ang tanong. One other. M, an unwed mother, gave her child for adoption to a childless couple, BC, for which BC paid 20,000. In the civil register of births, the father was listed as father unknown. 2 years later, after BC learned to love the child as their own and adoption proceedings commenced with required publication, F, the father of the child, appeared to oppose the adoption and to seek custody of the child. M sided with BC, claiming that F had abandoned her when he learned that she was pregnant, and declaring that she wanted BC to keep the child. Could BC recover the 20,000 they had paid for either F or M reasons? Well, definitely the answer is no. Okay. Effectively, M sold the child to the spouses, to BC. And obviously, the sale is a void sale because the object is obviously contrary to law, morals, etc. And the contract being an illegal contract, the impari delicto rule would be applicable. Whatever was delivered by one party to the other may no longer be recovered, as the court cannot give aid to either party to such contract. Okay?